This is a case which appeared before the Court of Appeal between the estate of Owen Dean Smith, the applicant, and Nilza Smith, the respondent. This is in 2021. Here, Dr. Mario Anderson for the applicant. That's the counsel for the applicant. Gordon Steer, instructed by Chambers, Bunny and Steer, the counsel for the respondent. Okay. On 26th of May 2021 and the 25th of June 2021, I have had the privilege of reading in draft, that's Brooks P. I have had the privilege of reading in draft the judgment of Fraser J.A. I agree with his reasoning and conclusion and have nothing to add. Okay. Fraser J.A. Remember Fraser. All right. Let's continue. So here, this is these are the judges, learned judges, the Honorable Mr. Justice Brooks P, the Honorable Mr. Justice Fraser J.A., and the Honorable Mrs. Justice Harris J.A. All right. So, Justice Brooks stated that he agreed with the reasoning of the previous court, the judgment of Fraser J.A., or not the previous court, the judgment of Fraser J.A. Fraser J.A., the applications, the applicant estate before this court seeks an order that one, the time within which to file an application to vary a discharge or discharge the order of a single judge, which was made on the 27th of November 2018, be extended, and two, the order made in chambers by P. Williams J.A. on the 27th of November 2018 be varied or discharged. The order of P. William J.A. is in the following terms. 1. On the material that has been presented, I am not satisfied that the applicant has crossed the threshold that there is a real prospect of success on appeal. Further, the applicant has not demonstrated sufficiently that the balance of hardship, irremediable harm, or justice favors the granting of a stay of execution. The order sought at 2 is not one that properly can be granted by me on the information and material relied on. In the circumstances, the application for a stay of judgment pending appeal is refused. The order for disclosure is also denied. 3. The applicant also seeks an order that in respect of the application for extension of time, there be no order as to the cost and in relation and in respect of the application to vary or discharge the order of P. Williams J.A. cost be awarded to him or in the appeal. The proceedings below. The judgment which P. Williams J.A. in the exercise of her discretion declined to stay was that of J. Pusey, AG, as she then was, the learned trial judge, LTJ, who on the 22nd of May 2018 in her judgment, Nilza Smith versus the estate of Owen Dean Smith 2018, made the following orders: that the claimant, the deceased spouse, is entitled to one half of the family home located at 16 Padiran Avenue, Kingston 6, in the parish of St. Andrew. 2. That the said property be sold on the open market or by private treaty. 3. The claimant shall receive 50% of the proceedings of the sale, and the remaining 50% shall be distributed among the beneficiaries of the will of Owen Dean Smith. In the action before the learned trial judge, the claim for half share in the family home was brought by the respondent after her husband, Owen Dean Smith, had died. At his death, his last will and testament, he devised 25% of 16 Fardian Avenue, the property, to the respondent and their daughter, 15% to his 50% to his firstborn, Robert Smith, and 25% to his other children, Angelisa Smith, Stephen Smith, and Randir Smith. The evidence accepted by the learned trial judge disclosed that prior to the death of Mr. Smith, the respondent was not living with him at the property. She, however, regularly visited, shared meals, paid bills for, and engaged in occasional intimacy with him. Additionally, it was accepted that the respondent maintained a room, furniture, clothing, and appliances at the property, took her mail there, and had free entrance to and exit from there. In arriving at her decision, the learned trial judge interpreted Section 6, subsection 2 of the Property Rights of Spouses Act to mean that an action could be commenced under the Property Rights of Spouses Act after the death of a spouse. Dr. Anderson, who also appeared below, was unsuccessful in persuading the learned trial judge that even if the Property Rights of Spouses Act was applicable, it would be subject to Section 7 and 10 of the Property Rights of Spouses Act, which could result in the variation of the equal share rule under Section 6 of the Property Rights of Spouses Act. Dr. Anderson renewed that submission before this court. The learned trial judge also found that the consortium continued between the claimant and her husband up to the time of his death. Hence, the property remained the family home as defined by Section 2 of the Property Rights of Spouses Act at the time of Mr. Smith's death. Therefore, based on the learned trial judge's interpretation of the Property Rights of Spouses Act and the evidence that was accepted, the respondent was successful in her claim. The effect of the learned trial judge's order was that the respondent now has a 50% share in the property outright and a further 25% share jointly held with Abigail, the child of the marriage. The application for extension of time, we will look at that in a different video.